Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest is Mark Erickson, and Mark is a family law attorney whose firm is located in Campbell, California. He graduated with a JD or law degree from Santa Clara University School of Law in 1979. He was admitted to the California State Bar and U.S. District Court, Northern District of California in 1979. After working for another attorney, mostly in the areas of civil and business litigation from 1979 through 1984, he founded his law firm in 1985. He became a certified family law specialist by the Board of Legal Specialization of the State Bar of California in 1987. He has lectured and presented seminars for many groups, including as a teaching assistant and guest lecturer at the Santa Clara University School of Law. And Mark's oldest son has followed in his footsteps, and now he's also an attorney and working in Mark's law firm. Today, we're going to have a continuation of a two-part program talking about child and spousal support relating to divorce in California. This is a complex area of law for which you should consult your own attorney, and divorce laws do vary among the states, so be aware of that. Now, if you would like to see the first part of this and you missed it, it will be posted at our website, Financial Insider Weekly, under past episodes. So financialinsiderweekly.com, under past episodes, and you just sort of scroll down and you'll see our various interviews that you can watch there. Okay, Mark, well, here we go again. Let's try to move along in this area of spousal and child support. Now, in the area of spousal support, and even in child support, can the roles change? You know, maybe a person's been paying spousal support, but suddenly the situation changes. Then what happens?
Well, absolutely. So child and spousal support orders are modifiable based on a change in circumstances. So it certainly happens where the parent or former spouse who was the recipient of child and or spousal support ends up being the payor. So the lower earner, who most likely is the recipient of support, may later be the higher earner if the former higher earner loses their job, or has a demotion, goes out of business. So there are various circumstances that could occur, and normally financial circumstances that could affect that, and so it's more common than you would think. And I always warn my clients at the beginning when we're checking boxes on the petition for dissolution of marriage or in a response to a petition, check the box that you want spousal support, because even though you expect to be the payor at the outset, months or years from now, you may be in need and be asking your former spouse to pay support to you.
Yeah. And you may feel it, oh, gee, I have a resolution. I know how this all works. And then suddenly, a little change in circumstances and things can really flip.
They certainly can.
Wow. Okay. Well, are there substitutes for support?
Well, in the area of spousal support, certainly people will negotiate settlements, particularly on a permanent or judgment spousal support, where they might agree to pay a lump sum in order to get a termination. So sometimes, especially if there's some predictability, the payor may say, you know what, I'd rather pay a lump sum right now than to pay an uncertain stream of payments into the future. And so hypothetically, let's just say you thought the spousal support was going to be $10,000 a month for 5 years. What's that, about $600,000?
Yeah, that's a lot of money.
It's a lot of money, but let's just say that was your best expectation. Then, of course, if you pay a lump sum, normally it's going to be paid as a non-taxable as opposed to a taxable, tax-deductible payment. So the payor paying $600,000 over 10 years was deducting those payments and now is paying a lump sum, we'd have to tax affect it. So we might take that 600 and now reduce it to 400, and then we'd look at the present value of that stream over 5 years and reduce it again to net present value. At today's current interest rates, that probably wouldn't be a big reduction, but you'd somehow reduce that 400, maybe you reduce it to 375 or 350. And then you look at the element of risk. Might this other person have remarried? Might one of us die? And offer a lump sum. And that's perfectly fine. The court would approve it. And in return, you would then ask for an absolute termination of the court's jurisdiction so that the other person could never ask for spousal support again and have it awarded under any circumstances. And normally when you do that, the payor would also enter into a waiver so they would not be able to turn around later and ask for spousal support.
Yeah.
Typically that's done where you have lower amounts for shorter durations. My hypothetical is maybe higher than some people would feel comfortable with, because if you're paying that lump sum, you have to accept that the recipient spouse might get remarried the next day or die the next day, in which case that spousal support never would have been paid for those number of years at that rate.
Yeah, to go out and get your bones that you throw to foresee the future, I guess, huh? Okay. Is there a role for life insurance when you're providing for spousal support?
There can be, yes. So the law does say that the court has authority to provide security for payment of support, which could be life insurance. It could be the provision of an annuity that might survive somebody's death. And so it's not uncommon to have an agreement for life insurance, particularly with higher earners and folks that either already have insurance or will still qualify to obtain insurance. And so if you had some predictability of what you thought the life of the spousal support order would be, you would have an amount of support sufficient to cover that, and often a provision that the amount of support provided could be reduced periodically as time went on, because the expectation less support would then be due as time goes on and payments are made. So it's fairly common. It's often a touchy issue because payors don't like the idea of the other spouse benefiting with a provision for payment upon their death.
Right. So let's see here. Can both the recipient of support as well as the payer of the support seek a modification of the support order?
Yes, and that comes up in both the child support and spousal support. Definitely in child support, the law says that child support can be modified based on a change in circumstances. The change in circumstances often would be a change in income of one or both parents, either up or down. The other area where we see changes frequently are the so-called timeshare factor. The child support formula determines both parties' net incomes, although we use gross income to put into the software, and the software calculates the net incomes after the tax factors are considered. But the timeshare factor is a determination of the percentage of time that the parents have primary physical responsibility for the child or children, and sometimes it's different for different children. And so let's just say that the initial child custody order was mom has the children 80% of the time, dad has 20% of the time, which might be, say, alternate weekends, half of the holidays, and a couple of weeks in the summer. And then the order changes, and now dad has the children 50% of the time. That change in the timeshare factor would be a justification to go back to court and ask the court to reduce the support because now that other parent has more responsibility and presumably more expenses related to having more time with the children.
Yeah. get that teenage daughter that says, I've had it with living with mom, I'm moving in with dad.
We see a lot of that with one or the other,
Yeah.
yes. Or children that are seeing the parents 50-50 and all of a sudden they absolutely refuse to see the other parent. Unfortunately, that's all too common.
Okay. And I guess, now, do you have to go to court? You have to get an approval in order to do this, right?
No,
Oh.
you don't.
Oh.
Certainly, it's possible if there's cooperation to change the order. So I guess in a perfect situation, if you had a change in your financial circumstances, you could call your former spouse and say, let's go have a cup of coffee. I'll show you my tax return and my current pay stubs, bring yours, and let's change the order based on our current circumstances. And some people are able to do that, probably not all too often. And then if you do reach an agreement, you certainly would want to put it in writing and file it with the court and have a judge sign it so you have an enforceable order. Unfortunately, over the years, I've seen people who've reached these informal agreements on a handshake or a telephone call, and so the payor, maybe he was supposed to pay $2,500 a month, and for the last 10 years has paid $500 a month, and now the recipient takes them to court and says, you owe me $2,000 a month for the last umpteen years, and if you don't have it in writing, you're probably going to lose. So if you negotiate a change that's in your favor, make sure you get it in writing.
Yeah. Okay. If you do decide to get this order, how long does it usually take?
Well, in the terms of a negotiation, I guess the best way to promote a negotiation is from a position of strength. If you file a motion or what we call a request for order or RFO with the court, a hearing date is probably going to be out maybe 5 to 6 weeks would be a common time frame. And during that time, a lot of people will exchange required financial information and reach an agreement, in which case they can be done either before they go to court or certainly the day they go to court without requiring the judge to have a hearing and make a decision. And in the case of post-judgment modifications, sometimes they're more complicated, where you have issues of underemployment or a spouse that was employed isn't working, and the other spouse or parent, former spouse or parent, believes that person is deliberately unemployed or isn't diligently looking for new work. When you get into those issues or disputes about what is the true income, sometimes those proceedings can take many months or sometimes years before they're resolved. You may go through a period of discovery. You may need multiple expert witnesses, such as a forensic accountant, perhaps a vocational expert, to assess one or both parties' ability to earn their education, experience, and what they can do if there are any health problems, and then match them with the job market and be prepared to come to court to testify about available employment that the person is qualified to take.
Okay. So if you're trying to do a modification for child support, what do you have to show in order to do that?
Well, of course, you're going to file your RFO, which is going to have some basic information about what's the current order, what was that order based on. You'll often lay right out what the incomes were when the current order was made, what was the timeshare factor as far as the percentage of time each parent was spending with the child or children. You'd also lay out what the tax factors were. Did somebody have deductible, or perhaps both parties, deductible mortgage interest, property taxes, and what was their tax filing status, which may have changed maybe before they were single and one, maybe they've remarried and now they're married filing jointly with a new spouse with multiple exemptions. So you would lay out what the old circumstances were and indicate how has it changed. Okay. Has the time you spend with your children changed? Has somebody's income changed?
Now what about for spousal support?
Spousal support, Sometimes the motions, I'll call them enough is enough, where somebody says, hey, we got divorced 20 years ago. I've been diligently paying my spousal support for 20 years. Judge, please put an end to it. I'm getting ready to retire, or I've just retired, and I don't want to pay anymore. And once you get out at a certain point, the court does have discretion to look at all the facts and circumstances, including the party standard of living during the marriage, length of the marriage, education, background, work experience, earnings history, and all of those factors, and determine if it's appropriate to have a termination date or not.
Okay. Are there any fixed rules or formulas for determining how long the spousal support order should last?
There's no absolute fixed rule for spousal support. The law says that half the length of the marriage is presumed to be a sufficient amount of time for a supported spouse to become self-supporting. However, that rule is looked at as a rule that doesn't really apply after a long marriage. The law says a 10-year marriage is presumed to be a long marriage, and so we usually would not be looking at the expectation of a termination date after a 10-year marriage, at least not immediately, although courts, certainly even after a long marriage, have the ability to make what we call a Richmond order, named after a case, in remarriage of Richmond, where the court can set an amount of support and then say it ends at this point in time unless the recipient comes back to court and demonstrates a continued need.
Okay.
So those orders are fairly common.
Okay. Now, you mentioned before, I don't know if it was in this interview or in the previous one, I think you just mentioned it a few minutes ago, the idea of making a lump sum payment related to your spousal support. Can you do the same thing related to child support?
No, you can't.
Okay.
The law is very clear. There's a public policy that prohibits taking away children's support. It's viewed as both something that belongs to a child or is in the public interest, and you don't know what the circumstances are. Could you imagine if you entered into an agreement for a lump sum child support when a child's 4 years old, and 10 or 15 years later, after lots of inflation, change in parties' incomes, lifestyles, where they live, there are all sorts of factors, child special needs. There could be a lot of reasons why that amount was insufficient, and of course, as we've talked about, sometimes the payor becomes the recipient. Mm-hmm. And so there's a strong policy that would prohibit that. Sometimes people do it, but if you try and enforce it, the court will not enforce an order like that.
Okay.
One thing we didn't talk about in terms of setting the amount of support that I think is important is we've assumed that the child or spousal support is a fixed monthly amount. Mm-hmm. And a lot of times that doesn't work because income is unpredictable. And we have what is commonly referred to as a Smith-Osler or Osler-Smith order, where the court sets a baseline, or you agree to a baseline amount based upon somebody's base income, but you recognize that they are likely to have additional income in the form of commissions that might be very substantial, stock option income, restrictive stock units, employee stock purchase plans, or other income that may come in that of an unknown amount and at unknown times. And so the order will provide that if and when that spouse receives the additional income, they will report it to the other spouse within some defined period of time and pay additional support on that income at a particular percentage for child support and another percentage for spousal support. And the order will often have an attachment because the amount payable, that percentage might change as the income goes higher or lower, that additional income, because of the tax rates changing.
Wow, okay.
And there's a lot of disputes over those, where later there's a dispute about what qualified as the income that should have been paid as additional support, or somebody didn't timely disclose it and pay what they should have paid.
Okay. So what if a spouse or former spouse doesn't pay their court-ordered child or spousal support? How does the supported spouse or parent go about enforcing that court-ordered child or spousal support?
Well, the law says that you can collect a support order that is unpaid the same way you could collect any civil judgment, and there are some additional methods in the area, particularly child support, available to see that these orders are enforced. One thing that's commonly done is at the outset, from when you first get your order, you can have a wage assignment, meaning the payments will be made directly from the payor's employer as they receive their check. Just as the income taxes come out of the check, the support comes out of the check, and the employer sends it either directly to the payee or through the Department of Child Support Services through the state. So a wage assignment is often a good way to make sure it gets paid. Unfortunately, that doesn't work well for the so-called Smith-Ostler if there's additional income. That can be problematic. We sometimes use a writ of execution, so if somebody falls significantly behind and you find an asset that's available, you can get a writ from the court, send it to the sheriff, and the sheriff will seize a bank account or other assets to satisfy the order. Another common way to enforce a support order is through the court's contempt power, where you're essentially acting like a private prosecutor. It's what we call a quasi-criminal action, where you notice the person who's not complied with the court order to come to court and answer why they haven't complied with the court order, and the court has the power to impose criminal-type sanctions, which, is, I think some of the people you see on the side of the road picking up trash might have been found in contempt for not paying their support order. They can be fined, including attorney's fees. So that can be a pretty serious remedy and an attention getter.
Yeah. So we've got less than 5 minutes left. Since spousal support is tax deductible, okay, we've talked about that to some degree. Are there any income tax traps that people should be aware of in negotiating a spousal support order?
Yes, and this is something that people that are trying to negotiate their own spousal support orders really need to think about. So the first thing is there are a number of requirements in the Internal Revenue Code for a spousal support order to be tax deductible. So sometimes people enter into agreements thinking their payments will be deductible and income to the other person, but if the order is not written properly, it may not be. And so the first requirement is it must be in a written instrument. So that's really important. And you have the option of specifically saying the order will not be deductible, so you can opt out of it. Another trap we see is if you have an order that's relatively high that drops off quickly the first few years, you can have what we call tax recomputation. So in any of the first 3 years, if the amount of spousal support drops by more than $15,000 from one year to the other, you're going to be in that tax recomputation trap. So you want to be very careful and either have a lawyer review it, or sometimes even lawyers will have a CPA test it if they look like they may be in that area. So you can avoid tax recomputation. I always tell people it's something like recapturing depreciation in a rental property. The other area is you cannot have spousal support terminate based on a contingency related to a child. What does that mean? Well, say your child is 3 years old and you agree to pay spousal support for 15 years, so that spousal support is going to end at the same time the child support would end when the child turns 18. That's going to be a violation and may prevent all of that spousal support from being tax deductible, even though you may have been deducting it on your return for 15 years. So that would be a huge trap. So this is an area where if you have any significant spousal support, you're probably going to at least want to consult an attorney or a forensic CPA that's familiar with the family law tax issues, and be very careful about that negotiation.
Right. So, and I think one of the key things is that the support has to terminate when the recipient spouse passes away, right?
Yes, and that's an automatic. So and you're right, the tax law says it must provide that it terminates on death. In California law, spousal support does terminate on the recipient's death, but you want those words in your court order to make sure it's a deductible order.
Right. So we have a little less than a minute left. Do you want to throw out a final thought?
Try and avoid spousal support litigation because it can be complicated, it can be very expensive, and I find that even when people are modifying a support order long after the divorce, the stakes are high, and these can be very difficult battles for people, and they view them as very important in terms of their lifestyle, and very difficult. I would do anything I could to try and resolve it without going through expensive litigation.
Okay. Mark, thanks again for joining me.
Thank you.
It's a very important subject. Folks, hope we've given you something to think about. Remember, this will be posted at our website, so you can tell your friends if they're dealing with these types of issues or family members. We'll see you next time on Financial Insider Weekly.